This is Twit.
Let's talk about Keurig for a second. This seems to be a patent-related issue. If anyone, I don't know if coffee purists out there think these Keurig things are just kind of too convenient and awful to tolerate, but they're certainly successful, and they're certainly easy and fast, and in my opinion, make a fine cup of coffee. I'm particularly a fan of their espresso machine that they came out with not too long ago. But hearkening back to some cases in the past about printer cartridges, printer ink, and garage door openers, it seems like Green Mountain, who has the license to make these Keurig K-Cups, doesn't want other people in that game. And the expiration of a patent back in 2012 seems to have allowed the flourishing of these various competitors to Green Mountain in the K-Cup field. But now Green Mountain is trying to lock that down. Do you have any take on this at all, Neil?
Yeah, so these are what are called razor blade industries, right? Where you can talk about in terms of printers and cartridges, razors, razor blades, and now it looks like coffee and K-cups. I think this is an interesting case. It's escaping me at the moment. I don't remember how there were a number of HP cases that were around, and they went very, very, I think they might have even gone to the Supreme Court around the printer ink cartridges. But I think this one's a little bit of a tough, unfair competition market because, the solution or unfair competition or antitrust claim, because really, people could go and buy a different device, or they could just use a normal coffee maker in their house. And the big issue to me is I've bought a lot of coffee makers over the years where they had some specialized filter of some sort. And I think that was pretty common that you'd go to the store and there'd be 4 or 5 different kinds of filters, and there'd also be the generic ones. And that never really seemed to present much of an antitrust or competitiveness problem. And the fact that they're now putting in, some sort of DRM to make sure it's an authorized one, I don't see why they're not allowed to do that as long as they notify consumers that that's what they're doing.
Right. It'll be interesting to see this play out because I know there is a lot of competition in this field. But Evan, you're just too busy drinking the gourmet Tonks coffee to worry about any of this, aren't you?
That's right. I'm much too highbrow, but I can peer over and to see what the proletariat are doing with their K-cups and see, and examine all this. So, and what a lightning rod issue we have here. It's like, come on, Keurig, you get everybody hooked on your product and just really fortify the caffeine addiction that everybody has, and then you go and pull a stunt like this using DRM. What a like I said, what a lightning rod issue here. So what a great scenario, factual context to reinvigorate people talking about DRM and by extension the DMCA, Section 1201, Section 1202, the anti-circumvention provisions. This harkens to the like we were talking about. I think, Neil, you said HP. Maybe you're thinking of the Lexmark cases. I don't know the relationship between Lexmark and HP if there is one, but I know all down in Kentucky in the Sixth Circuit, there's been litigation. I think may even still be ongoing on some issues. It's been going on probably 10 years or more about whether or not it's appropriate for, microchip technology to allow certain printer cartridges to be used in certain models of printers. There was some litigation about 10 years ago involving Chamberlain, the garage door opener technology here in the Seventh Circuit that and evaluated some similar issues. So I think what's lurking behind all of these discussions is this question of, is the new form of liability, and by new I say since 1998, we're looking at a long view of history here, the new form of liability that came about when the anti-circumvention provisions of the DMCA were enacted. Is this the scenario that is appropriate for that liability to be put in place here? Because ostensibly, the idea was that the anti-circumvention provisions were geared to protect means of access and means of copying of copyright protected works. And so I guess the theory is here that the DRM and this is where I'm just extrapolating. I haven't looked into the particulars of what Keurig has to do here, but conceivably the remedy for circumventing or hacking your new Keurig machine so that it didn't work here, the remedy would be, among other things, a violation of the anti-circumvention provisions of the DMCA. So the question then becomes, is that how we want things to be governed? Is that the mechanism? Is it really copyright that should step in and serve as a set of remedies, to provide a set of remedies and impose obligations on the consumer in this context? So with a popular brand like Keurig and a popular consumer product like coffee, if this thing goes forward as what we're hearing, it could really lead to some pretty provocative discussions about anti-circumvention and DRM and the DMCA in general.